Hi, this is Dr. Ishita Sharma, and in today's lecture, we are going to discuss the concept of causation under the law of torts. In civil law, the concept of factual causation is fundamental, and a thorough grasp of its nuances is crucial to deciding a variety of instances. The objective of this paper is to provide an in-depth look at the concept of factual causation, including its definition and application under different circumstances. Through an examination of the but-for test, a crucial technique for determining factual causation, you will acquire a more profound understanding of the practical application of this principle. Furthermore, the intersection of the two concepts under tort law shall also be analyzed, including important topics such as negligence. The same shall be illustrated more comprehensively through real-life examples as well as judicial interpretations that have influenced the development of the above-mentioned concept of the law of torts. Now, coming to understanding the concept of factual causation, the but-for test forms a crucial component of the concept of factual causation. However, the test is not devoid of confusion. The same can be illustrated through an example. Let us take the example of death. Let's say I caused the death of another individual as a result of my negligent act, say by rash driving. Now, death is a certain part of our earthly existence. Now, does this mean that I have a strong defense to the death of the individual against the legal action initiated against me by his or her legal heirs? I contend before the court of law that death is the ultimate zenith of human existence, and the individual dying is a natural corollary of his or her existence. A fallacious argument, isn't it? Such a frivolous defense would nullify all negligent acts that cause the death of another individual. However, the courts are apostles of logic and reasoning and do not accept such a line of argument. Such a stance also dilutes the factual causation principle of tort law. The non-application of the factual causation principle in cases of death would lead to death being a lesser tort than causing a mere injury to another. However, one pertinent point emerges from the concept, that is, the principle of specificity. The specificity principle requires that the occurrence of an injury be corroborated with the exact time and place of its occurrence. In relation to the hypothetical situation of death illustrated above, the prime question to be seen is whether the injury that led to the death of the individual at the time and place that it occurred would have occurred even if I was cautious while driving. The spatial and temporal dimensions are very essential. Otherwise, the defense of certainty of death would be taken by every tortfeasor in cases of this nature. The illustration given above is only in relation to the factual causation test. There are, in reality, several other dimensions to be taken into consideration while deciding the culpability of an individual for death by negligence. Thus, factual causation is an essential element in deciding the culpability of a party under civil law. This idea is essential to figuring out if a certain action or occurrence is directly proportional to the damage or wrong suffered by a party. This part of the process focuses on establishing the causal link between a particular act and the damage that ensues as a result of the act. Now, summarizing this entire concept, it is the establishment of a coherent connection between the damage suffered by one party as a result of the negligent act of the other party. Until the claimant is harmed as a result of the defendant's unlawful actions, there is no onus of liability on the defendant. The requirement of some kind of damage due to the act of the defendant is not the sole litmus test to determine culpability. In other words, the twin dimensions of legal as well as factual culpability must be established. The but-for test is the widely recognized method for determining factual causation. The primary question that is asked is whether the damages would have been incurred by the claimant independent of the conduct of the defendant. If the answer is in the affirmative, there is no cause of action. It is a purely factual question whose burden of proof is solely on the party claiming damages. Now, coming to the types of factual causation, seeing it through the lens of cases. The cases of factual causation can be bifurcated into two categories: simple and complicated. Under the simple category, there is no culpability on the part of the defendant for the harm caused to the plaintiff. It is prima facie clear from the facts of the case that the injury would have happened irrespective of the negligent act of the defendant. That is, even if the defendant had exercised care and caution. Now, under the latter category, the same is ambiguous. That is, whether the injury would have happened despite the exercise of due care and caution. The cases in the latter category have an intervening element that adds to the negligence of the defendant. The primary question to be decided here is whether the defendant's act was fundamental in causing death or the intervening factor. Primarily, the law around factual causation is woven around cases in the latter category, that is, the complicated cases, wherein multiple factors are responsible for the tortious act. However, it is also essential to look at cases in the former category for a comprehensive understanding of the concept. Now let's see some simple factual causation cases. In cases in this category, the defendant's act plays no role in the harm caused to the plaintiff. It is an irrelevant factor altogether. The same can be understood in a hypothetical situation. A cricket ball overreaches a fence and hits a passerby. The passerby brings a case of negligence against the owner of the cricket ground, alleging negligence on the ground that the fence encircling the cricket ground wasn't high enough, thus jeopardizing the safety of the passerbys. Now the fence is 15 feet high, with the defendant asserting that the reasonable height should be 25 feet to prevent such instances. The court accepts the line of reasoning put forth by the plaintiff. However, the same is heavily flawed. An in-depth analysis of the facts shows that the cricket ball drifted over the fence at a height of 30 feet. The illustration shows that the negligence of the defendant played no role in the injury caused to the defendant. It is a completely irrelevant factor altogether. The failure of the owner of the cricket ground to construct the fence at a reasonable height has no role to play in the injury caused to the defendant. The same can be illustrated through a real court case. In the case of Perkins versus Texas and New Orleans Railway Company, the plaintiff was a passenger in a car that came onto a railroad track with a train coming from the opposite direction towards the car. The train was headed towards the car at a speed of 37 miles per hour against its mandated speed of 25 miles per hour. Overspeeding was a negligent factor. However, here the question that arises is whether the accident could have been avoided even if the train was within its speed limits. The evidence showed otherwise. The train would not have been able to stop and prevent the accident from happening even within its speed limit. Additionally, there was no evidence to show that the accident could have been avoided by the plaintiff, even if the train was within its speed limit. The evidence points to the irrelevance of the negligence of the train driver in the accident. There are other kinds of cases under this category wherein other contributory factors dilute the gravity of the negligence of the defendant. The same can be illustrated through an example. A goes to a car wash shop. While his car is being washed, the water jet for cleaning the same has been negligently set at an excessively high pressure by its handler, resulting in the same injuring A. However, the injury is due to A's negligence in keeping his car window open in the midst of an ongoing car wash. However, later on, during a detailed investigation, it was revealed that the pressure of the water jet stream was so strong that it would have broken the glass pane of A's car, irrespective of whether the window was open or not. The given illustration throws light on the gravity of the negligence of the defendant that overrides A's negligence. Now coming on to complicated factual causation cases. As the name suggests, these kinds of cases are the ones where the negligence of the defendant plays a crucial role in the occurrence of a mishap. It is these kinds of cases that largely circumscribe the domain of factual causation. The focal point of litigation is the cases in this category within the concept of factual causation. Herein, the but-for test fails to solve such conundrums. This has led to the evolution of substantial factor test. The literal meaning of the word substantial is something that holds relevance. Hence, the substantial factor deals with the question of whether the act of the defendant played a relevant or substantial role in the mishap or not. Now coming on to the tests and definition of factual causation. As we have seen, there are two tests for determining factual causation. The but-for test, that is, was the accident inevitable despite the negligence of the defendant? And the substantial factor test, that is, was the negligence of the defendant the prime cause of the accident, injuring the plaintiff? A cursory glance at the phrase gives the impression that the latter test is more effective. However, the same is not true. The problem lies in a precise definition of the latter test. There are several unanswered considerations, such as what constitutes substantial, the feasibility of conditions for the applicability of such a test, etc. This is the reason for the test taking precedence over the substantial factor test. The substantial factor test comes into play only when the negligence of the defendant is prima facie overwhelming enough to contribute to the plaintiff's injury. The same can be illustrated through a hypothetical scenario. A and B separately negligently start a forest fire, which on joining creates an even larger fire, destroying C's house in the process. The but-for test, in the instant case, creates a confounding situation, since each of the actors, A as well as B, would argue that the mishap would have occurred irrespective of his starting the fire. This is where the substantial factor test comes into play. It is generally used in cases of multiple tortfeasors who contribute to the injury of the plaintiff. Cases of such nature, wherein the acts of multiple tortfeasors, whether remote or proximate, lead to the use of such a test. Going by the word cause, if the act of the individual who is the injurer breaches a legal standard, the outcome will be a mishap causing injury to another party. Contrary to this, there can be a situation where there is no breach of a legal standard by the injured, but the mishap is due to the occurrence of some intervening factors. Regardless of negligence by the injurer, the intervening factor plays a crucial role in causing the injury. The same can be illustrated through an example. A, while checking fish sacks, did not exercise due diligence in notifying his supervisor about their improper stacking, which led to injury to him while attempting to unload them. The court ruled contributory negligence of A in causing the accident, since his failure to exercise due diligence in informing his senior of the improper stacking could have averted the tragedy, but only if timely intervention by other workers could have occurred. In this given illustration that I just narrated, the negligence of the plaintiff is not the prime cause, nor is it overwhelmed by other factors. There was nothing to indicate that the exercise of due diligence could have averted the tragedy or led to the intervention of his co-workers. The court reached the conclusion that A would have been injured even if he had notified his superior of the improper stacking. The above hypothetical vindicates the relevancy of the substantial factor test in the resolution of convoluted scenarios, since it involves a closer scrutiny of facts. The substantial factor test is akin to assessing the gravity of several scenarios, creating several branches of the cause of the accident. Then the next step involves assessing which branch is the prime cause of injury and how it is heavier than the other branches, which are remote from the cause of injury. This is the procedure adopted in the substantial factor test. Another case that deserves mention here is New York Central Railroad Company versus Grimstad. A, the captain of a barge, falls overboard as the barge bumps into another ship. A's wife was also on the ship in a cabin at the time of the accident. While coming out of the cabin, she sees her husband struggling for help since he does not know how to swim. She rushes back to her cabin, searching for a rope to save him. However, upon her return, she finds him missing. She files a suit of negligence against the defendant, claiming the lack of lifebuoys on the barge that contributed to the tragic demise of her husband. However, the court did not take into consideration the argument of A's wife. It ruled that A's contention was based on conjectures. There could also be a situation where, despite the availability of lifebuoys on the barge, A could not be saved due to inaccessibility of the same, or despite their easy access, she herself could not throw them in the nick of time so as to save him. The Grimstad case can be likened to the Perkins case that I already narrated above. The excessive speed of the train was not a prime cause in Perkins, and the absence of a lifebuoy was not an irrelevant factor in Grimstad. But applying the assessment of the gravity of the branches test outlined above, the other branches overpowered the absence of the lifebuoy branch in determining the guilt of the defendant. Thus, the decision in Grimstad could have been reached within the application of both kinds of tests. There are several branches of consideration in Grimstad: the presence of lifebuoys on the barge, their accessibility, timely outreach to the drowning captain with the lifebuoy, throwing the same at an accessible distance in the water, and finally the captain actually grasping the lifebuoy in time. These branches all require due assessment in determining the guilt of the defendant, whether he has taken reasonable care or not. This creates a very complicated situation in the determination of guilt. This is a case wherein the several branches outweigh the prima facie appearance of the scenario. Prima facie evidence did not suggest that the branches played a role in the drowning of the captain. However, when those branches are taken into consideration, the defendant is absolved of guilt. The negligence of the defendant was not a substantial factor in the tragic accidental death of A. Grimstad belongs to a class of cases that lead to the same outcome irrespective of the application of the test, that is, the substantial factor test or the but-for test. The prime cause needs to be determined based on several factors and the gravity of each cause. The question that is to be determined is whether the negligence of the defendant superseded all other branches, akin to a but element in the determination of the guilt of the defendant. The same can be understood in another case, in Reynolds versus Texas and Pacific Railway Company. A woman hurried down a stairway to board her train before it left the station. As she descended the stairs, she fell. She had just exited a brightly lit waiting room into an unlit stairwell, which led to the mishap. However, the defendant contended that the mishap could have occurred irrespective of whether the stairwell was lit or not. Hence, the lighting of the stairwell is not the proximate cause of the accident. Despite the contentions of the defendant, she won the case. Now, the Grimstad case and the Reynolds case can be compared. The lighting of the stairwell is a primary consideration in the occurrence of the accident. There are other branches of causation to be considered in addition to the prime cause. However, the difference is in the causation factors from the sides of the defendant and the plaintiff in both cases. It is very logical that the transition from a well-lit room to a dark, dimly lit area leads to visual difficulty. The same can be fathomed by a rational individual. The factors superseding the prime argument in the Reynolds case need to be overwhelming, enough to absolve the guilt of the defendant. From the facts of the Grimstad case and the application of rationality, it is very clear that just the availability of a lifebuoy on a boat is not sufficient to save a drowning individual. Thus, the nature of the contentions and the facts of each of these cases are unique in their determination of the guilt of the defendant. Now, coming to the conclusion, the discussion that we've just had elucidates the concepts of causation and the tests that aid in its determination. Both the tests are unique in their own way, as the application of both involves proper contextualization of the facts of the case and a proper assessment of the scenario that led to the mishap. As can be seen from the cases that I've just narrated, there are varying perspectives and interpretations of a particular set of facts. As can be gleaned from the Perkins and the Reynolds cases, though the facts seem to be of a similar nature, but with the application of rationality, proper logic, and contextualization, the outcome differs. Hence, in the determination of the tort of a tortfeasor, a cautious application of the tests is essential for the proper determination of the guilt of the accused and the quantification of damages. With this, we come to the end of the lecture. Thank you so much.